The next case to come before the court is Tracy Blackmon et al., the Akron Public School Board of Education et al. Each party will have up to 15 minutes to present your argument. The appellant may reserve up to 5 minutes for rebuttal, and if you do plan to reserve time, if you would let me know, I can help you keep track of that time. Arguments are being recorded, so please stay behind the podium, introduce yourself, keep your voices up. You should not use the names of children or victims or minors, should that be relevant to your argument. You can refer to those folks by initials or terms like the child. We have read your briefs and we're ready to proceed when you are. And I would just ask the appellant, would you like to reserve time for rebuttal?
Yeah, just 5 minutes, please.
Okay, very well. And we are ready when you are.
May it please the court. My name is Matthew Smartnick and I represent the appellants in this matter, the APS officials that were named in the lawsuit brought by appellees. A plaintiff cannot circumvent the immunity protections afforded to a political subdivision under 2744.02 of the Ohio Revised Code by suing the named APS officials who allegedly were involved in the policy decision to not have metal detectors or other heightened security features at the football stadium. That's exactly what's being attempted here. The core basis of appellees' claims in this matter is that there should have been metal detectors or heightened security measures at this football stadium on the night in question. And the policy decision, allegedly, not to have those features in place is negligent, reckless, willful, wanton, some heightened standard as alleged in the amended complaint. But a political subdivision can only make this alleged type of policy decision through individuals acting in their official capacities. That's why the APS officials are included in this lawsuit. They were the persons allegedly to have been involved in the policy decision not to have metal detectors or other heightened security measures at the football stadium. The basis then for the claims and the factual allegations in the amended complaint between the political subdivision and the APS officials are one and the same. You take the APS officials out of this amended complaint, basically it's the same complaint. It's the same allegations about this policy decision not to have metal detectors. The law is clear in Ohio that the type of immunity analysis a person gets under 2744 is dependent on the type of capacity that person is sued. So official capacity, it gets the analysis under 2744.02. It's the same as the political subdivision. If the person is being sued in their individual capacity, that's when 2744.03A6 is triggered. The amended complaint in this case doesn't have them listed as in their individual capacity. And under SMITEC, this court's decision in the 9th District, when they're not named in their individual capacity, it's well within the court's purview to determine that they're being sued in their official capacity. The clear and unambiguous language in the amended complaint shows that the APS officials were named in their official capacity zone. And we just need to look at the beginning of the complaint, how the individuals are captured. Vassilotti, for instance, is being sued in his capacity as Director of Athletics at Akron Public Schools. Nolan is being sued in his capacity as Principal of East CLC. Blondheim is being sued in their capacity as Athletic Directors of East CLC, and you can see from the amended complaint, it goes onward. Even David James, the superintendent, he's being sued as the superintendent. He's no longer the superintendent. And same thing with Dan Ramler. He's no longer head of security and director of student support. Paragraph 9 of the complaint, amended complaint, goes further and shows that there are allegations that they're being sued in the capacity in their leadership or director level positions. Again, policy, they're the ones allegedly making these sort of policy decisions on behalf of the school.
I have a question.
Sure.
I know you're warming up to say that if the judge dismissed at the Akron board on an immunity basis, and this is official capacity, then they should have dismissed your clients, but doesn't that whole argument presuppose that the judge's ruling was appropriate in the first place? And if it wasn't appropriate in the first place, then isn't there an issue here?
That the issue is that the trial court applied the incorrect analysis. The trial court should have applied the analysis under 2744.02 because the persons were sued in their individual or official capacity. And accordingly, then the trial court's decision should be reversed, and they should be immune, just like the political subdivision.
But what if that original dismissal is erroneous of the Akron board? Then that's not the analysis here.
Well, that's not the issue for appeal. The political subdivision, the granting of the immunity of the
Right.
political subdivision is not before this court.
So the question that is should a judge not dismiss Akron School Board, but whether these other defendants should be dismissed as a separate analysis? I think you're intertwining it with the first decision that isn't before the court.
Well, for the same immunity analysis, I would suppose that they would be immune if they're followed under 2744.02 and you apply that analysis to them. Is that on the APS officials? Yeah, so there is no exception to immunity under 2744.02 that would apply to them, just like there's no exception for the political subdivision that would apply.
Correct. So, but I'm saying, what if the premise is, your premise is that the judge got it right dismissing the Akron School Board? What if that premise is wrong? That's not before us.
Sure,
So-
yeah, if that premise is wrong, then for the same reasons that the APS officials wouldn't apply, they wouldn't be immune as well. But the point on this appeal is that the claims are one and the same, so there's one analysis that should apply here, and that's under 2744.02. Alcus versus Bainbridge kind of goes in and talks about the differences between individual and official capacity. They're sued, according to Alcus, sued in their official capacity when the substance of the complaint fails to specifically allege that the person's name transcended their official duties, or it states that they were in their official capacity, or that the individuals, no allegations that the individuals took personal actions. Official capacity is when allegations do not, or individual capacity is when allegations do not challenge policy, or practices. So, applying the inverse from Alcus, then we have a case where they are challenging. It's clear from the complaint they are challenging policy. So that's indicative of their being sued in their official capacity. The named APS official should be entitled to the same immunity analysis as the political subdivision. And the court should reverse the trial court's decision and grant judgment as a matter of law in favor of appellants based on immunity. Alternatively, I prefer the first option. Alternatively, the trial court's decision should be at least reversed and remanded to the trial court to apply the immunity analysis, the correct immunity analysis under 2744.02 to the APS officials. And if there's any other questions, I'd be happy to answer them.
Does the language in the complaint that alleges that a person did something maliciously or recklessly indicate an intent to sue them individually?
No, I think that's skipping. It's assuming that they're sued. It's assuming 2744.03 would apply, but before that, you need allegations that would show that they transcended their official duties and they're being sued in their individual capacity. So before that, before we get to the go ahead.
Even in a notice pleading state?
I think you need from the complaint, there's no inference that they're being sued in their individual capacities from the complaint. It doesn't say they're sued in their individual capacities. To the contrary, it shows, I would argue, that they're in their official capacities because they're being sued with their titles. It says that they're leadership, director level positions, they're policy-based arguments, and the only way a political subdivision can act in terms of policy is through their employees. So they're acting in their official capacity to make policy on behalf of the political subdivision.
The trial court does take note of the case law that says that if you're acting in your official capacity as an individual making choices, you can still be individually liable for those choices that you make. I mean, the trial court zeroes in on that case law. So, in a situation where there's a judgment on the pleadings, is that insufficient law to support what happened here? Because I understand the argument is that you didn't go through the analysis you were supposed to go through to get to the conclusion that you got to. But then we have this other case law that's kind of been there. And I wondered if you had any response to that.
Yeah, I think there isn't a whole lot of case law on this. specific issue. I think normally from the case law, it's noted what capacity they're being, usually it states either official or individual or both. It doesn't have it here. I think the case law allows, when you don't have that, you have to look at just the face of, you have to look at the amended complaint under SMITAG. And I think there's no inference that they're being sued in their individual capacities from this. It's everything that it's clear that they're being sued in their official capacities. I think this is a matter where if it was pled, I think if it was pled, I'm suing them in their official and individual capacities, I think for the pleading stage that would be enough. But when you don't have that, then you have to actually look at the allegations, and it's a fiction. It's one and the same. And with that, I think I'm down at my time. There's no other questions. I will reserve the remainder for rebuttal. Thank you.
Good morning, Your Honors. My name is Paul Flowers, and I'm representing the plaintiff appellee, Tracy Blackmon here. I'm joined by Phil Masters, who's the trial counsel for Ms. Blackmon. I thought I'd start off with Judge Hensel's question, which I thought really got right to it. Judge Croce was right on the mark on this. These types of decisions we see routinely, and she cited all the appropriate case law, and she got it right exactly. And Judge Hensel, you're right. I mean, specifically on page 4 of her decision, she cites the Emmerich versus High School case. She quotes it. It is well settled that a suit against an employee of a political subdivision in the employee's official capacity is an action against the entity itself, and the employees are entitled to the same immunity due to the political subdivision. And then she cites this SMITAG case we're hearing so much about. That is true. You sue an employee in the official capacity, the city's on the hook, and you go through the B1, 2, 3, 4, 5 analysis. But that does not mean that you do not also go through the allegations of malicious, reckless misconduct, which is under an entirely separate subsection. So Judge Glazinger, that was what you were asking about, and that's a very simple answer. I mean, that's under RC 2744.03A6, which eliminates immunity for the employee if A, the employee's omissions were manifestly outside the scope of employment or official capacity, or B, the employee's acts were the omissions which were malicious purpose, in bad faith, or a reckless and wanton manner. If he's right that you have to allege something that transcends the official capacity, that it has to be beyond their official duties, which none of his cases say, but if he's right about that, then you can never hook a city on political subdivision immunity. B will kick in. B will kick in because they're outside, or A will kick in. They're outside the scope of their employment. City's not involved, political subdivision immunity doesn't matter. You sue that person truly personally, where it's just them because they were on some lark or frolic and they weren't in their official capacity doing official duties. But if you're alleged reckless, wanton, malicious misconduct, you go to that step. Because if that happens, it doesn't matter that the city's off the hook under subsections B1, 2, 3, 4, and 5. Now you can hook the employee for their extreme misconduct and get the city that way. We've always done it. I've argued this approach in front of this court dozens of times. The Moss case that's been cited so much, that's a good example. We were up here twice on that case arguing the same thing. And this court has followed the same approach. You look at it first under the B1, 2, 3, 4, and 5 to see if the city's directly liable, and if there's allegations of reckless, wanton, malicious conduct, then you go to the next step, which is under the part I just quoted under 03A6.
Do you think you shot your clients in the foot by putting their official title in the heading and not in individual capacity?
No,
Because putting the title does imply that you're pursuing an official capacity.
right, no pun intended, I assume. So my client was shot in the leg, no, not at all. We always do that. Because you have to say that these people were acting in the course and scope of their employment. And when they're officials, that means they're acting in official capacity. Because that's the only way the city can be liable.
But isn't the custom to put in official capacity as principal and individual capacity right up front?
Yeah, I've definitely seen that done, but I don't know that it's a requirement, and we're just notice pleading here. Yeah, I've definitely seen that done. I mean, official capacity, we talk about that when we're talking about injunctions and mandamus, prohibition. The mayor is supposed to spend funds on a certain project and he's not doing it, you file a mandamus action against the mayor in his official capacity. So we all know he's not being sued personally, it's official capacity. And judges, all our mandamuses against judges are in their official capacity as a judge, not as personally. I mean, here it's the same thing. It's just that you've got this A6 that says that if it's reckless, wanton, malicious, then we have an exception to immunity for that, that's separate from the B1, 2, 3, 4, 5 exceptions. It's another step, which Judge Croce got exactly right. So if you look at, one of the main cases there's, oh, yes.
Sure, that's okay, jumping in. So in all those cases about whether someone put a coffee pot too close to the edge, or a police officer threw down some stop sticks, well, everyone is acting in their official capacity. They're not cases about decisions made about policy. And I think that there was some individual act. So I guess the question becomes, like the Rothrock Road case where there was an official legislative act of a vote about what the city was going to do with something. How does that square in terms of individual liability or immunity?
Right, no, exactly. His contention that our case is all about policy, he's reading it that way. That's his reading, because it gets him where he wants to be. We don't know that this was all about whether or not there's policy. The complaint suggests that the policy was there should be metal detectors, because it alleges that there had been metal detectors in the past. If we do discovery, and it turns out that this policy existed for metal detectors and these people were not following it, that's reckless in my view. It might be even worse than reckless. So this could be a case just like Moss, where there's a policy, they're not following. So Moss is the coffee pot case, where the individual defendants were all teachers and were responsible for who had put the pot of coffee too close to where the special needs student could reach it. So yeah, this whole policy thing is all just reading the complaint in a very specific way that we don't know is going to be the case because no one's done any discovery yet. If it comes out to be totally a policy case, which is hard to imagine, about should we have metal detectors, shouldn't we, then we could address that on summary judgment. But for right now, I don't see that happening, because I really doubt that they said, hey, we're going to make a big change in policy for this game only, and we're not going to have metal detectors. No, it's far more likely that the policy was, you need security, we know we need security, and for whatever reason, these people didn't provide it that night. Just going back to the Molnar case, and this is the one that they cited initially, it's a prime example of this two-step process. I mean, there you've got an action by a former employee who's arguing about whether or not the officials should have destroyed his termination documents. Is it a policy? Isn't it? I mean, who knows? Maybe the policy was there, didn't follow it, or maybe there's no policy at all. This court applied that two-step process, and the city and individual employees lost on both steps. There's a potential claim against the city, there's a potential claim against individuals for reckless and wanton misconduct. That's exactly the same thing here. And then the Moss case we've been talking about, same thing. The teachers individually could be held liable in that case, in their official capacities as teachers, for what they did and did not do that day. The Moss case was being cited as actually the first one. The second one was summary judgment, and that didn't turn out so well for us. But that's where the issues were all sorted out, was on summary judgment. And that's the situation here. It's just far too early on the pleadings alone to decide whether or not there's a policy or not, and whether it was followed or not. So with that, we would ask you to affirm Judge Croce. Thank you.
Thank you. You will have your full 5 minutes.
Thank you. So, I want to address this, I guess the argument that just because there's allegations of recklessness in the complaint, we don't have to discuss what capacity they're being sued in. So, the way that Appellee's interpretation of this, it would essentially get rid of 2744.02. In fact, if you're criticizing a policy, all you would have to do, and you can't get around 2744.02, you just name the persons that would be part of that policy-making decision, that would be allegedly making that policy decision. The cases that are cited to in Appellee's brief in opposition actually point the opposite, where the examples that are given, the employee is actually doing something separately from the political subdivision. So, you know, for instance, like supervision, there was a case where the child was not being watched appropriately, and the allegation the employee was not supervising enough. They're individual type of actions apart from the political subdivision.
But wouldn't all that get fleshed out on summary judgment, not judgment on pleading? Because at this point, it's notice pleading.
Is there, but the question is the issue is there anything in the amended complaint that would give an inference that these individuals are being sued in their individual capacity? So you have to meet that threshold first. If it states that they're in their individual capacity, or it talks about how they transcended their official duties, which is one of the factors that's mentioned in AUKUS, then it would be sufficient, and then it would have to get fleshed out for summary judgment. But the appellees haven't got to that point in their pleading, even with notice pleading. And just looking at the amended complaint, on paragraph 5, it states that all defendants, Akron Public Schools, Vassalotti, Nolan, Linger, all the rest of the named ones, even the city of Akron and the deputy mayor was at it, all lumped in, all lumped together. All these individuals were the ones that had this policy in place. So it's one and the same. It's an action against the political subdivision. And the individuals that are allegedly part of that policy-making decision are in their official capacity. And there's no other interpretation that can be seen from the allegations in the amended complaint. And with that, I would again reaffirm my position, appellant's position, that the trial court's decision should be reversed. Thank you.
Thank you both for your presentation. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of that